Marshall, Texas is a small town in the eastern part of the state, the kind of place better known for railroads and roses than for the future of the internet. But in January 2003, it became the venue where one of the largest technology companies in the world tried to stop one of the smallest from becoming its rival. On January 22nd, Cisco Systems filed suit in the United States District Court for the Eastern District of Texas. The defendant was Huawei Technologies, a Chinese networking company most Americans had never heard of. The complaint was long, detailed, and unusually specific about a single accusation: that Huawei had not merely competed with Cisco, but copied it. Mark Chandler, Cisco's general counsel, laid out the claim. Huawei, he argued, had taken Cisco's intellectual property, its software, its command structure, its manuals, and built a business on top of it. This was not a vague charge of imitation, it was a charge of duplication, and Cisco said it could prove the copying line by line. The heart of the case was a kind of forensic fingerprint. Software, like writing, carries the marks of its authors. Two engineers solving the same problem will almost never produce the same code in the same order, with the same mistakes. Identical errors are not evidence of a shared problem. They are evidence of a shared source. Cisco's networking gear ran on iOS, the Internet Operating System, the software that told its routers how to move data across the world. Over years, that software had accumulated bugs, small, idiosyncratic flaws, each with its own internal tracking number. They were Cisco's flaws, particular to Cisco's code. Huawei's routers sold under the Quidway brand carried some of the same bugs. Not similar bugs, the same ones reproducing Cisco's specific defects in Cisco's specific way. A flaw is an accident. The same accident twice is a copy. Then there were the manuals. Cisco alleged that Huawei's documentation reproduced its user guide so closely that it carried over Cisco's typographical errors, the stray words and misprints that no independent author would ever reinvent. A company can write its own description of how a router works. It cannot independently arrive at the other company's typos. There was the matter of the command line interface, the text language an engineer uses to configure a router. Cisco's interface had its own grammar, its own quirks. Huawei's, the complaint said, mirrored it closely enough that Cisco-trained technicians could operate Quidway machines as if they were Cisco's own. And there was EIGRP, a routing protocol Cisco had invented and kept proprietary, never licensed for outside use. Huawei's equipment supported it. There was no legitimate way to support a protocol that existed only inside Cisco's code without having been inside Cisco's code. To understand how Huawei arrived at this moment, you have to go back to 1987, and to a man named Ren Zhengfei. A former engineer in the People's Liberation Army, he founded Huawei in Shenzhen, then a young special economic zone across the border from Hong Kong, with very little capital and no technology of its own. In the beginning, Huawei was a reseller, importing telephone switching equipment made by others and selling it inside China. The ambition was always to make its own gear. The fastest route to making your own gear in the China of the 1990s was to study someone else's. The strategy that built Huawei's first decade was undercutting. Western networking equipment was expensive, and it dominated the markets of the developing world. Huawei learned to build comparable boxes and sell them for far less, expanding first across China's countryside and then into Asia, Africa, and Latin America, the markets the giants paid least attention to. Reverse engineering was central to that climb. You buy the competitor's product, you take it apart, you learn how it works, and you build something that does the same thing for less. Done carefully, it is legal and ordinary. Done carelessly, done by lifting the actual code and the actual manuals, it is theft. Cisco's complaint said Huawei had crossed that line. By 2002, Huawei had begun selling routers in the United States and Europe, advertising them on the one argument that mattered: the same performance as Cisco at a fraction of the price. For Cisco, which earned its margins on exactly that gear, this was not a distant nuisance. It was a competitor undercutting it with what Cisco believed was Cisco's own work. So Huawei faced a fork. One road was to fight, to contest in an American courtroom under American copyright and trade secret law, the question of whether its code was its own. That was a road through hostile territory on Cisco's home ground with the forensic evidence already public. The other road was to maneuver, and here Huawei made the move that mattered more than any courtroom argument. In March 2003, weeks after the suit was filed, Huawei announced a joint venture with 3Com, the established American networking company led by Chief Executive Bruce Claflin. The venture, later known as H3C, paired 3Com's name and market credibility with Huawei's engineering and low costs. For 3Com, struggling against Cisco itself, an alliance with a cheaper rival was a strategic bet. For Huawei, the timing did something else entirely. It produced an American executive willing to vouch for it. Claflin gave testimony in the litigation that served as both legal and reputational cover. He told the court that 3Com had examined Huawei's operation and found a substantial, legitimate engineering organization, thousands of developers doing real research. A Chinese company accused of copying could be dismissed. An American chief executive staking his own firm's reputation on Huawei's competence was harder to wave away. The case did not go to a verdict. In 2003, the court granted a preliminary injunction. Huawei was ordered to stop selling the products at issue in the United States and to pull back the disputed software, command line interface, and documentation. Crucially, the parties agreed to let a neutral, court-supervised expert examine Huawei's source code, an independent review of exactly what was inside the machines. Under that scrutiny, Huawei's posture shifted from denial to remediation. It set about rewriting the offending code, replacing the command line interface, and reissuing the manuals. In July 2004, after the independent review and the rewrites, the two companies settled. The case was dismissed. There was no enormous penalty announced, no public confession, just a quiet end and an agreement that the disputed elements were gone. Cisco had made its point. Huawei had absorbed it. The cost for Huawei was not really the settlement. It was the lesson. The lawsuit had demonstrated in open court and in the trade press that copying was a dead end, that a business built on someone else's code could be unwound by someone else's lawyers. Huawei could not climb into the developed world's markets as a copyist. It would have to become an inventor. What followed was one of the most aggressive research investments in corporate history. Huawei committed, as policy, to pour a large share of its revenue back into research and development every year, a figure that over time grew into the billions, employing tens of thousands of engineers across a global network of laboratories. The company that had once bought competitors' boxes to study now built campuses to out-engineer them. The patent filings followed. Within a decade, Huawei had moved from a name associated with imitation to one of the most prolific patent filers in the world, routinely ranking at the top of international applications. A company can copy its way to a product. It cannot copy its way to a patent portfolio. That had to be earned, and Huawei set out to earn it. And there was the compliance culture, the quieter consequence. Having been caught once, in detail, Huawei built internal controls around intellectual property, rules about clean room development, about what engineers could reference, about documenting that work was original. The point was not only to be lawful, it was to never again be vulnerable to the precise kind of evidence Cisco had assembled in Marshall, Texas. The strategic result arrived within 10 years. The company that had been branded a thief did not retreat from networking. It deepened in it. Huawei pushed past 3Com, past the rivals it had once merely undercut, and into direct competition with Cisco across Europe, Asia, Africa, and the Middle East, winning the large carrier contracts that are the real prize of the industry. By the 2010s, Huawei was no longer Cisco's cheaper imitation. It was a full-spectrum equipment maker with its own research, its own patents, and a lead in the next thing, the build-out of global mobile networks, where Cisco was barely a factor at all. That is the irony at the center of this story. The lawsuit was meant to stop Huawei. Its visible effect was to halt one product line and end one quiet case. Its lasting effect was to force Huawei to stop being the kind of company that could be stopped that way. The humiliation of 2003 did what no business plan had managed to do. It converted a reseller and reverse engineer into a research company because copying had been proven, publicly and forensically, to be the more dangerous path. The rival that Washington would later treat as a strategic threat, barred from American networks, fought over in capitals around the world, was not the company Cisco sued in 2003. It was the company Cisco's lawsuit helped create, disciplined about its own intellectual property precisely because it had once been caught with someone else's, and formidable precisely because it had been forced to become so. The case in Marshall ended with a settlement and a dismissal, the smallest of conclusions. What it set in motion was the largest. A typo, a bug, a borrowed manual, the marks of a copy, turned out to be the marks of a beginning,